Case of Blue Heron Point Apartments.
This Texas landlord-tenant courtroom hearing begins with what seems like a simple rent dispute between Blue Heron Point Apartments and tenant Melissa. But it quickly becomes clear this case is far more complicated than unpaid rent. Behind the numbers are disputed late fees, escrow disagreements, and a growing breakdown in trust between both sides. What should be a routine civil matter starts building emotional weight as a court tries to separate legitimate charges from potentially unfair penalties. And very soon, this hearing takes an unexpected emotional turn that no one in the courtroom was fully prepared for.
Late fees, essentially what the ledger boils down to is my client is alleging fees, June and July rent. I believe my client will have a different position on the fees after we talk today.
Gotcha.
And if we could adjourn it, perhaps 3 weeks, that would give us time to enter a conditional dismissal if the court would allow. And I would ask if we even need to appear if we did have a conditional dismissal hammered out.
If everybody signed on a conditional dismissal, I wouldn't need to have you here. I would just indicate that there is, I'm not going to be good at math this time of day, but there's, it's probably about 4,045 maybe, somewhere around there, in escrow. So whatever conditional dismissal you have,
Here the attorney explains that the main issue centers around a disputed insufficient check fee and additional late charges tied to rent from June and July. The defense is pushing for conditional dismissal, arguing that once both sides reconcile the ledger, the matter may be resolved in a few weeks. But what stands out is a confusion over exact amounts, escrow balances, portal totals, and disputed fees ranging around hundreds of thousands of dollars. The court also begins to question whether these late fees are legally justified, emphasizing that fees must reflect actual collection costs, not serve as penalties. This is where the case shifts from a simple payment issue into a legal examination of how landlords structure fees.
So supposedly I'm only on $1,955.72. All my emails
Hold
and
on.
calls.
when you say that's what you're owing, is that after you applied the escrow?
Yeah.
Oh, okay. All right. Go ahead.
Because right now the portal is showing I owe $8,454.52.
And there's
54.26.
there's 5426. And what was your number again that you gave me?
The portal says $8,454.52.
So and you haven't put, how much is your monthly rent?
My rent is supposed to be $1,800 a month.
18. And so obviously July kicked in that figure.
Right.
That you're,
It's the July rent plus the EBS bill, and that includes the trash, utility, sewer, water. So that's why it came up to $1,955.70.
gotcha. Okay. And so hold on, I just want to make sure I'm viewing this correctly. Given that there's really $1,500 or thereabouts in fees.
That's, Your Honor, I would say in dispute. And I believe my client would.
Over what period in time?
This would be since February, there's been a balance. The last time there was a zero balance was January 6th of 2023.
Whoa.
So late fees.
Yeah, I hear you, but the fees, like, how much are the fees typically a month?
So late fees are approximately $100 a month.
Yeah.
There are various utilities that are approximately $45 to $50 a month.
Paid all my utilities on time.
And Your Honor, these sorts of costs are the things that I'd like to discuss with my client. I
Yeah.
believe we're close to a settlement.
And I'm going to say this, and it's always been the posture of this court, that certainly in certain circumstances, landlords can charge their late fee. But a late fee can't be just liquidated damages, and it can't be, which is a hard thing for landlords to realize, it can't be a penalty. Late fees have to be related to the cost of collection. There's case law specifically on that point. So maybe this will aid in your discussion with your client that what they don't want me to do, which a couple complexes have done, is to under court's order, give me the cost of what it is to collect and show that relationship to the late fee charge. I don't think they want to do that. It is an onerous task and not worth it, the benefit of any of that. You okay, ma'am? Go ahead and have a seat. You all right?
Sir, this whole thing has caused me so much stress. I had a miscarriage on Monday.
Oh,
And
I'm
not even
sorry.
supposed to be here. I'm supposed to be on bed rest. But
Sure, let us
this is
know.
very unfortunate. This is harassment. They have been harassing me. And I have to go through this the last few months.
This is the most emotionally intense moment of the hearing. The tenant breaks down in court, describing extreme stress linked to the housing dispute, miswork, and even a miscarriage. The emotional weight instantly changes the courtroom atmosphere. The judge responds with sympathy, but also attempt to refocus the discussion on resolution, assuring her that the situation will work itself out. Still, the moment highlight how legal disputes over housing are not just financial. They can deeply affect a person's health, stability, and mental well-being. It raises a difficult question. Should courts treat these disputes purely as contracts or consider the human impact behind them?
And I know it can't alleviate any past stress you've had. I'm going to tell you right now, do not worry about it. This is all going to work itself out. I'm giving very clear signals to them where my perspective on this whole thing is. I remember when you first brought up the fees, and you have to remember that sometimes people are always talking about the fees that they're charged, right? And you don't think the fees can add up and whether or not they're fair to be there. And then you find out with most people, it's not really the fees, it's that they haven't paid the rent. What I see from you and what caused me concern and why we're really set like this now is because when I asked you to, for example, put your rent into escrow, you weren't missing a beat getting it in. So that kind of thing tells me something. All right. But I would prefer that what you do is take care of yourself and we can do this. The next hearing that I said I will not make in person. You can appear via Zoom on this if it's necessary to appear. I would hope that this can all be worked out. Okay. All right. You're welcome. Was there anything else you?
The lawyer was very kind to speak to me.
Pardon?
I said the lawyer was very kind speaking to me before. It's just unfortunate.
Yeah. This kind of unfortunate thing happened. That's my entire Friday. So I get it. I get what you're saying, and it shouldn't be this way. And you get the stress comes from the notion that the sort of that basic thing that we need in life in terms of housing. Also, that's all being jeopardized, and especially if I don't understand why it's being jeopardized. That's a problem. All right, but they've got the figure on the portal. You've got the 5,400 in escrow, you're in good shape on this case. I mean, because however it works out, okay? You're welcome. You're not related, I probably should have asked, but I don't think, to any of the
Yes, ma'am.
Ann Arbor Ketchners?
That is my family.
Okay, so I'm just gonna tell you this, and it has no bearing on how I decide the case. So the very first time I called the case, I thought about that. I'm trying to think which one went, I think I went to high school with a couple of them anyway. So I called the name and I said, that's a unique name, but I mean, I know the
We
folks.
don't have ones here.
Okay, so I didn't know, right? And so I'm thinking that then I don't know which appearance it was. Who's your dad? Are you
Jonas.
who?
Jonas Ketzner.
Jonas? No, I can't think of who I went. I can't.
Armor.
Is there a Ronald? No, it was.
Racing.
What about John?
That's my uncle.
John's your uncle. Okay, that's I think who I went to high school with. But I'm going to tell you what kind of got me was I don't remember what day it was, but my screen for looking on Zoom is over here, and I called it, and I could see John's face in yours.
That's my favorite uncle.
Is it so? I looked at her, I said, yeah, she's got to be one of those Ketchners. I said, well, at some point, I'm just going to ask because it was driving me crazy for a while. And I don't know if you know my sister, Delphia.
They probably do.
I'm sure they do. And I had to ask her. I said, how many Ketchners are there? Because she would know better than I would. She had better memory than that. So, okay. So thank you for doing that. Because if I hadn't asked today, I would have spent the weekend like, I should have asked because I know that. And then when I would have called the case, I would have said, I would have seen the face and I would say, that's a Ketchner. I just want to say something.
Thank you.
So where's John now?
Passed away.
Oh my gosh. How long ago?
As the hearing continues, the judge explains that escrow payments and disputed balances suggest the tenant is actually in a stronger position than expected, depending on final calculations. The court also hints at broader concerns about how late fees are structured across apartment complexes, reinforcing that penalties must be legally justified. Despite the tension earlier, the judge ultimately adjourns the case for 3 weeks to allow both sides to negotiate a conditional dismissal. The tone softens at the end, with personal remarks and reassurance directed at the tenant before the next hearing is scheduled. This case shows how civil housing disputes can shift from financial conflict to deeply personal courtroom moments before eventually moving towards structured legal resolution.
Everybody take care. Ms. Kitson, take care of yourself, please.
She needs somebody to take you or?
I'm just gonna take it slow motion.
Okay.
You'll be good?
Yeah.
Okay. Don't be falling out in my hallway, you hear me? All right. Okay, take care. Have a good weekend. 14-8.
Please subscribe to help the channel.